Yep.
Okay, well, good evening, everyone. I'm Stephen Schneebaum, and together with our introducer this evening, our moderator, Marty Flaherty, I'm one of the co-chairs of the newly formed International Law in Domestic Courts Committee of the American branch of the International Law Association. This is our inaugural event. The committee has just been formed, and we are looking forward to an interesting panel this evening, of course, and an active agenda at International Law Weekend in November or in October of this year. My job at the moment is the easiest one. I am simply here to welcome everyone, to introduce you to the new committee, the International Law and Domestic Courts Committee of ABILA, to invite all of you who are ABILA members, or even those of you who are not ABILA members, to join the association and then to join this committee. And now I will introduce our moderator, my friend and colleague and co-chair of this committee. Marty Flaherty is the Leitner Professor of International Human Rights Law and the founding co-director of the Leitner Center for International Law and Justice at Fordham University. I suspect most of you know Marty. And so, Marty, over to you.
Okay, thank you very much, Stephen, and my thanks to Stephen for upfront for helping organize what I think will be a very interesting and stimulating panel. I'm coming to you today from my other academic home, Princeton, where I'm visiting professor at the School of Public and International Affairs. And I can't let this opportunity go without plugging my recent book that is relevant to the business of this committee, Restoring the Global Judiciary, Why the Supreme Court Should Rule in Foreign Affairs Law, available at all good websites everywhere. Today we are going to, we have a great panel for this inaugural event about the Supreme Court's most recent pronouncement on the Alien Tort Statute. And I have been asked by the panelists to give at least a short précis of what the ATS is. I'm sure many who are here today are here precisely because they know something about the Alien Tort Statute and have followed the recent developments concerning it. But surely many of you have not. So particularly for those people, let me try to say a little bit about what it's about and how we got to this particular case. So it used to always be said, so what is the ATS? The ATS is a statute that is deceptively simple. It is one sentence long and says as follows: the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. That's the modern language. It has changed language over the course of 2 centuries. Once upon a time, it was always there was always a quote given by Judge Henry Friendly concerning the ATS, which was, "It's kind of a legal Lohengrin. Although it has been with us since the first Judiciary Act, no one seems to know whence it came." Well, that might have been true at one point, but there's been a substantial amount of research on the ATS since, not least by some of the members of this panel, indeed by all of the members of this panel. So let me talk about, summarize the ATS in really sort of 3 parts. Part 1 is its origins. It was passed by the first Congress in arguably its most important statute, the First Judiciary Act of 1789. It was Section 9 of that First Judiciary Act. I have read the text. There is ongoing debate about what it was intended to do. For myself, I think it's pretty clear that it was at the very least intended to be used as a mechanism for aliens to go to US federal courts and sue for tort violations that violated what we today call customary international law, both to prevent the United States from getting into foreign policy tangles and also arguably to defend the honor of the United States and its commitment to international law, although even those points have been debated. What has not been debated is that it was barely used for 200 years, less than a handful of court cases, and perhaps more importantly, at least two early attorney general's opinions about which we will hear later. But after a long, almost 2 centuries period of dormancy, it was revived and transformed, arguably, in a 1980 case decided by the Second Circuit called Flaherty versus Peña-Irala. And that case ushered in a period in which the ATS essentially became a vehicle for victims of international human rights violations to use US courts to plead their cases and to have internationally respected forum like US federal courts to pass on their claims. Flaherty itself involved the family of a Paraguayan student who was disappeared under the Paraguayan dictatorship in the 70s, who then immigrated to Brooklyn. And it just so happened that the police chief who was allegedly in charge of the disappearance of their loved one was also there. They went to the Center for Constitutional Rights to see what could be done about this, and creatively the Center for Constitutional Rights dusted off this statute. The Second Circuit let the suit go ahead in an interesting opinion by Judge Irving Kaufman, not ordinarily associated with a robust defense of civil liberties. But Flaherty ushered in really at least a decade of international human rights litigation by victims of human rights. And those who were defendants were basically a who's who of the authoritarians around the world. So that was for many the golden age of the ATS. But by the 90s came a period of pushback. And at least this is my own interpretation, that pushback was not unrelated to the fact that in a second wave of ATS suits, litigants started adding corporations to the list of defendants, specifically naming corporations as aiding and abetting states and state actors in the violations of international human rights. And indeed, that is what the Nestle and Cargill cases are going to involve. Well, when you sue corporations tend to get better lawyers than Paraguayan police chiefs. And that led to some pretty vigorous and robust and creative lawyering against the ATS. And that in turn resulted in a trilogy of Supreme Court cases, the first of which more or less sustained the ATS and framed its use, but then subsequently 2 cases that greatly restricted it. The case that more or less sustained the previous ATS litigation was a case called Sosa versus Alvarez Mashain. In that case, the Supreme Court held, and the challenge to that case was that the ATS is purely a jurisdictional statute and doesn't provide for a cause of action. And were that a modern statute, that would not be enough. Modern statutes need to have Congress include a cause of action or provide for a cause of action. The ATS doesn't do that. Nonetheless, the court said that when the ATS was enacted in 1789, Congress's expectation was that the federal courts would use their common law powers to fashion causes of action based upon recognized violations of the law of nations, which today more or less translates into customary international law. The ones that the court specified that was on the mind of the drafters of the statute at the time were piracy, assaults on ambassadors, and violations of safe conduct. And as I say, the conventional wisdom was that SOSA more or less confirmed the first wave traditional ATS suits, but left in some doubt the status of the subsequent suits involving corporations. Well, that doubt was clarified in subsequent two cases, Kiobel and Jesner. In Kiobel, the court applied the presumption against extraterritoriality to the ATS and held that an ATS suit could not go forward unless it touched and concerned the territory of the United States. That was a unanimous opinion, although Justice Breyer wrote a concurrence that tried to flesh out exactly what that meant. Then in a subsequent case, Jesner, the court held that the ATS, even though it didn't specify who the defendants could or couldn't be, could not be used against foreign corporations. That, however, left open the question, could the ATS be used against domestic corporations? And going back to Kiobel, it left open the question, exactly what does extraterritoriality mean? All of which brings us to the current combined cases from this term that our panelists will discuss. So toward that end, we couldn't have a better group of panelists to discuss these developments. They will be in order: David Golub, Hiller Family Foundation Professor of Law at New York University School of Law, who will be followed, we will start off with Paul Hoffman, sorry, Paul, who is Adjunct Clinical Professor, University of California, Irvine School of Law, and partner at Schonbrun, DeSimone, Seplow, Harris, and Hoffman. He will be followed by David Golub. David will be followed by Mike Ramsey, who is Hugh and Hazel Darling Foundation Professor of Law and the Director of the International and Comparative Law Programs, the University of San Diego Law School. And then finally, Beth Stevens, Distinguished Professor of Law at Rutgers Law School. The format today will be fairly straightforward. The panelists have been asked to speak for about 10 to 15 minutes with their reflections on what the Supreme Court did in the recent Nestle / Cargill case. After that, time allowing, we will have a colloquy among the panelists and then a Q&A. And I would ask members of the audience to supply their questions in the chat function here on Zoom, which I will then moderate and manage the queue. So without any more from me, you're all here to hear the panelists. So let me turn things over to one of the advocates in the Nestle case, Paul Hoffman.
Thanks, Marty. Thanks for the invitation. So let me give you my hit on what the significance of the Supreme Court's decision is. First, I want to start with the good news, from my standpoint at least. The best news is that the issue of corporate liability, I think, is off the table now. Justices Alito and Gorsuch are on record now as saying that corporations can be sued under the Alien Tort Statute. Justices Sotomayor, Kagan, and Breyer have already said that. There are 5 justices on record as saying that there's no corporate immunity for claims under the Alien Tort Statute. So the issue that the court granted cert on in both Kiobel and Jesner without deciding it, I think is essentially decided. It's not a holding, but I can't imagine that lower courts will treat it as anything but an endorsement of corporate liability. And I think, in fact, there's a case in the Fourth Circuit where the parties have agreed to dismiss a pending appeal, which was based on corporate liability. I think that's what's going to happen in the future. The other good news, I like starting with good news better when I get back down to the less good news. The Solicitor General asked the court to find that there's no aiding and abetting liability under the Alien Tort Statute, which would have wiped out more than just our case, obviously. The court seems not to be interested in that argument whatsoever. And it's hard to imagine that that they will take that up in that form again. Another piece of good news is that all of the categorical arguments that the defendants made with respect to the presumption against extraterritoriality and how it interacted with aiding and abetting liability were not accepted by the court. They weren't exactly rejected, but the defendants argued that anytime the injuries took place outside the United States or the underlying violation took place outside the United States, that there should be a bright line rule that there could be no liability under the Alien Tort Statute. The court seemed completely uninterested in drawing any bright line in this decision. I don't think it can be read as even indicating an interest in that. On the less good news, I think it seems to be that the court, at least 8 members of the court, have firmly adopted the sort of Morrison, RJR Nabisco way of looking at how you determine a domestic applicability of a statute, right? Because in Kiobel, they found that the presumption against extraterritoriality applied to the Alien Tort Statute, leaving the second step in RJR Nabisco, which is, are you making an argument for a domestic application of the statute? Meaning, have you alleged enough conduct within the United States to constitute aiding and abetting on US soil, largely. What the court did not decide, and it seems to have left open, is exactly what kind of conduct satisfies that test, right? The end of section 2 of Justice Thomas's opinion says, to plead facts sufficient to support a domestic application of the ATS, plaintiffs must allege more domestic conduct than general corporate activity. And it found that the allegations in the complaint that we filed constituted general corporate activity and were not sufficient under this standard. And those kinds of actions included things like providing some money, training, exclusive contracts, general corporate oversight. In our briefs, we made it clear to the court that we had been given the opportunity to amend our complaint, and then on remand, we would amend our complaint to allege more direct conduct from the United States in terms of these defendants' control of the supply chain of cocoa based on slavery. Whether that will satisfy the court's test, it's not clear, because the court really didn't establish a test. It said one thing that it's not, but it didn't really say what it is. And I suspect what's going to happen in the subsequent cases, both in our case and the handful of pending cases that have survived Kiobel, we're going to litigate what kind of conduct is enough to establish the kind of domestic application of the statute that overcomes the presumption against extraterritoriality. I'm looking forward to a wave of motions to dismiss and other supplemental briefing in a number of cases around the country that have a variety of fact patterns that will be the next wave that establishes, what that means. But right now, it's pretty unclear what that means. And I don't know that the court, I think that the fact that the liberal wing of the court and the conservative wing of the court got together on an 8-justice opinion suggests that there was some agreement not to define it any farther than they did, and to leave that open for further elaboration. One of the oddities of the case is that Justice Alito dissented on the ground that they should have decided corporate liability explicitly, and they should have waited until we amended our complaint, which I think is the first time that Justice Alito has ever voted for a position that I've had. So miracles can happen, and it is not clear where the court's going on this. I mean, overall, obviously, that the fact that they didn't rule for us suggests that there's still some skepticism among many members of the court about the entire exercise here. And they've obviously called for Congress to give more guidance about that. Whether Congress is capable or interested in doing that is another question. And I think that, you know, there's obviously been a big ideological divide over how to look at this, both within the context of the ATS narrowly and, you know, more generally in terms of what the role of the court should be in creating causes of action. So I think the bottom line for, you know, a litigator like me with cases is that we live to fight another day, both in this case and in a number of other cases. And there are some sort of interesting and some might say perplexing aspects of the case. I know that David will talk about one of them, which is why the court ignored history. I'd be interested. I'm certainly interested in hearing what his take is, because he found some memoranda from Thomas Jefferson and Edmund Randolph, and I thought that might be kind of persuasive. In fact, I put it in my opening 2 minutes, but it didn't get into the court's opinion. So that's how I see that. Now, the other one other thing I think, which is also extremely important, and that is, and Marty talked about the SOSA framework. Section 3 of Justice Thomas's opinion would basically wipe out the SOSA framework and would go back to the position that Judge Bork took in Teleran versus Libyan Arab Republic. The idea that basically the Alien Tort Statute means only what Blackstone thought it might mean in 1789 and nothing beyond that. The thing that's interesting to me is that in SOSA, there were three votes for that position. I think it was 3. It was Scalia, the Scalia dissent. And there are 3 votes for it now. So they haven't gained a vote in 17 years. There are only 3 justices that seem inclined to abandon the SOSA framework. And so that SOSA left open the possibility that this statute could be used in at least some circumstances. And I suspect one of the things that will mean is that some of the cases below will continue, and some of them will be resolved, and some of them may settle. And it's still, the Alien Tort Statute remains as a potential vehicle to vindicate the human rights claims of at least some plaintiffs in this context. And where it goes from here, obviously, you know, no one really knows. So why don't I should stop there and let others talk, and then give us time to debate what this all means.
Great. Well, thank you very much, Paul, for your insights, especially since you were there in the trenches. So next we'll hear from David Golub about history, and I suspect much else.
Well, thank you, Marty. You did an admirable job in summarizing a long and complicated history of the Alien Tort Statute. And Paul gave a very nice and optimistic presentation of where we stand after this decision. And I suppose even after Kiobel and Jesner decisions. And I think it's certainly an admirable trait in an advocate to be optimistic about what comes out. But, you know, I'm looking at it from a slightly different perspective. And I would say, well, you might say, if Paul's was an optimistic assessment, I have a very cranky assessment. And in general, I think that, I guess it is, of course, terribly important that the ATS lives, and there's still room for all kinds of possibilities within whatever is left over. But it is a case of, you know, a giant box having gotten halved, gotten quartered, gotten a 1/16th, 1/32nd. There's little ways in which maybe it still survives, and of course that means in the future, you know, with some miraculous changes in the court, you know, that could be revived, I suppose. I'll speak about the court's decision, but before I speak about the court's decision, which, you know, I do find and this is an indiscreet way of putting it, but I would say reeks of the Trumpism of our era. Before I elaborate on that assessment of the decision, let me say a little about the history that was pertinent. Well, it wasn't pertinent to what they did, but seemed to be pertinent to the issues that were in front of the court. So, as Marty explained and Paul discussed as well, one of the major issues that emerged as a way of cutting back on the scope of the Alien Tort Statute as it had developed after the Flaherty case and had been affirmed in the Sosa case in the early 2000s, like 2004. I'm sorry, I lost my train of thought. So what was I going to say? Sorry. Okay, anyway, one of oh, I'm sorry, yeah, of course. So the crucial point was that a large portion of the cases dealt with suits by foreign nationals as is required by the ATS, but against foreign actors, foreign violators or alleged violators of their human rights, rather than against American citizens or American corporations. That development came somewhat later on. So a large portion of the cases were, as it were, foreigner against foreigner, if you want, in the ATS litigation. In the Kiobel case, the ruling was on extraterritoriality. How far did the statute apply to extraterritorial conduct? The court ruled that there was the presumption, as Marty said, the presumption of extraterritoriality applied to the ATS, and therefore, with possibly limited exceptions, that the statute would not apply to conduct that occurred outside the United States. It was a sort of a general ruling in the Kiobel case. And on that point, as it were, liberals, although they concurred in the judgment in the case, they dissented on that point. They rejected the idea that the presumption against extraterritoriality should be applied in the context of a statute that deals with foreign issues, like the Alien Tort Statute. And they explicitly said that it shouldn't apply where the defendant was an American. If you want, in terms of the majority opinion, it therefore would touch and concern the United States if the defendant was an American citizen. In that case, in the Kiobel case, the defendant was not an American citizen, was a foreign corporation, it was a Royal Dutch Shell Company. And therefore there was no, according to the court's decision, that didn't touch and concern the United States. Well, in the Nestle case, the situation was somewhat different because the defendants were US corporations, raising the question whether or not it was, if you want, the case was distinguishable, if you want, from Kiobel, because in Kiobel, as I said, the defendant was a foreign corporation. Here, it was an American corporation. Now, I think Marty described some of the background purposes of the ATS, even though, notwithstanding all of the controversy about that. And I think, just as a general comment, it's worth pointing out, I think also Marty mentioned this, that there are a few areas of statutory interpretation and constitutional interpretation where early American history has been more plumbed for trying to discover what the meaning of the relevant provision is. Here, the Alien Tort Statute. I mean, really huge amount of work has been done by scholars on trying to figure out what the purpose of why it was passed, how it was developed, how it would have been understood at the time that it was adopted. And much of the court decisions in the Supreme Court, so to some extent as well, but certainly in Kiobel as well, and in the other case, the Jesner case, history played a very central role. A lot of speculation about the context in which it was adopted and how to interpret it in that context. So history has always played a very dominant role in the understanding of the ATS in the courts and among the law scholars who've been debating it. So the issue, one way of characterizing one of the major issues in the case, the Nestle case, the most recent case, was would the court treat the extraterritorial aspect of the case differently in a case where the defendant was an American corporation than it had when it was a foreign corporation. It was a U.S. national defendant. And the answer appears to be from the decision that they won't. Well, here's where the history enters into at least my presentation right now, which is that it happened that I came across some time ago some important early documents. There were memoranda written by Thomas Jefferson as the first Secretary of State during the first Washington administration, and Edmund Randolph, the first Attorney General of the United States. They're both of their preeminence as well, I think, known to everybody here, their status in the founding generation. And these were memos I came across looking for something else. And they're quite important memos in a number of respects because they contain within them a lot of implications and relevant statements about important constitutional issues that go beyond the ATS, and much of which has to do with international law and domestic courts, the subject of this subcommittee. In any event, they also dealt directly with the ATS. That was a part of the discussion. And for some reason, which I really have no explanation for, because these were not, I didn't pull these out of the Library of Congress in handwritten form. They're in the Thomas Jefferson papers and other papers published and widely available even online. And yet, notwithstanding the decades of historical research about this period and the reliance on much less probative evidence, very thin and not very probative evidence that's existed before. Here were memos that directly addressed the question of whether or not the ATS applied to offenses against the law of nations, torts against the law of nations, committed by American citizens in foreign countries. So there was. Now, and that was brought forward in an amicus brief to the court. What do the memos say? For lack of time, I won't try to give you the full picture. The simple version of it is that as early as late 1791, Thomas Jefferson, as Secretary of State, was receiving a lot of diplomatic complaints about the activities of American citizens in other countries, principally in the Floridas, which were Spanish, or in the Caribbean, and then where they were either French or they might be British or whatever. There were a number of these incidents where Americans did something that the foreign country characterized as a offense against the law of nations, as a violation of their rights under the law of nations, and they were in the nature of torts. And the question of with these diplomatic complaints coming to him, Jefferson had to think about what he could do, what the United States could do, what the legal framework that existed in the United States at that time, based on existing statutes and other existing principles, jurisdictional principles as well, what could be done by the federal government about this. He began contemplating it seriously in response to two incidents. One was in East Florida, and the other was in Martinique in the Caribbean. Both involved American citizens crossing into a foreign territory and taking enslaved persons out. Now, I won't go into the details, but in each case, they were able to abscond from the jurisdiction with the enslaved persons who they brought back to the United States and converted to their own use. And that gave rise to diplomatic complaints by Spain and by France. And this is what Jefferson was facing. He took it very seriously. We have his diplomatic notes, the back and forth, his efforts. They both came out of Georgia, his efforts to deal with the governor in Georgia to try to get prosecutions against the individuals and see what else could be done and so on. And as he was engaged in that process, he began to think, well, what are the powers of the federal government with respect to this? He did two things. One is he became troubled about it, and he decided to tell Washington about it and asked Washington to include it in his annual message, what we would call the State of the Union. It was then written, his annual message, with Congress to try to get whatever legislation might be necessary in order to fix if there was a lacuna in American law. Second, he thought about what is the status of American law in this respect. And what he said was, then he writes a memo about this, which actually was a memo very likely for the Senate Foreign Relations Committee, the Senate Judiciary Committee, headed by Oliver Ellsworth, the author of the Judiciary Act of 1789, as well as the ATS as part of it, and earlier versions of the ATS in Connecticut, which was often thought to be the source of the ATS. He too was the author of that, so he was quite familiar with this. And he in response to the message, he set up a meeting with the committee and Jefferson. So Jefferson writes a memo just to say what he thinks about the law in this, on this subject. And what he says very briefly is, well, we have a problem because we don't have criminal jurisdiction. We don't have a statute that creates jurisdiction in the federal courts to prosecute violations of the law of nations. But we do have civil liability in the United States because we have the Alien Tort Statute, which he then quotes. He titles the memo "Defect in the Law on Crimes Committed by Americans in Foreign Countries." Okay, so if the extraterritoriality here isn't clear, the title says everything about it, I suppose. And he writes the memo and he affirms that under the ATS, there's civil liability for these extraterritorial acts as torts, but there isn't criminal liability. And he says maybe civil liability would be enough, but sometimes the violation, there won't be an alien to sue as required by the ATS for some reason, because it's a public violation, not necessarily affecting a particular alien who would then have standing to sue. And so we need criminal liability as well. That's the analysis he gives. He gives the memo to Randolph. He writes a statute, actually a criminal statute, to accomplish this. He doesn't write a civil statute, he writes a criminal statute, as he suggests. And then he gives the memo to Randolph, who concurs on both, and writes his own memo and concurs. Not only that, he concurs on the Alien Tort Statute being available, but he tells Jefferson he's also wrong about criminal liability. There is a criminal statute that's all that's needed, which is the Section 11 of the Judiciary Act. This is a very significant concession by Jefferson in relation to a number of very important debates of the early republic, including most importantly, the federal common law of crimes and other important constitutional issues during the period. Skipping all of that, which is what I was looking for when I found these documents. So they both agree. And then apparently the meeting happens, although we don't have a record of it. And Jefferson must have been a little embarrassed because he put this language in the statute, in the president's message. And he arranged, therefore the Senate comes to him for a meeting with Oliver Ellsworth and the committee in tow. And he comes in and says, actually, Randolph was right. In his memo, he writes an addendum to his memo. He says, Randolph, I see, you're right. You're right. We don't need the criminal statute either. Okay. So there you go. So we have, really, I don't know, it's hard to imagine more powerful evidence that the ATS, as it was understood by leading statespeople of the early republic after it was passed, included the idea that it would be applicable to torts committed by American citizens abroad. Now, to get to the court's decision very briefly, the most recent decision, what's quite remarkable, because after all, the case was a case involving a suit under the ATS against an American corporation for action torts committed in a foreign country, and therefore was on all fours as far as I can see with the memos. The court simply decided to ignore it. Not dismiss it on some phony ground or find a way to distinguish it as they are wont to do in these circumstances, but simply to ignore it. And that was, in Justice Thomas's opinion, he simply ignores it. He also ignores the clear implication that that the Sosa decision was correctly decided in light of the understanding that's expressed in these memos, even as he's writing effectively to argue for the overruling of Sosa. So in both respects, he simply ignores the overpowering historical evidence there. But what's more striking even than that, I suppose, is that the liberals joined without saying anything, even when they had dissented on this point in Kiobel. So they now go along with the majority and they just go on to defend Sosa. And they don't talk about this material even in defending Sosa either. So that creates a difficult phenomenon to explain. I'm going to very briefly offer two explanations, which I can go into more later, but they're just speculations. One is a kind of general speculation, which is that what's become so important to the liberals now, across a very wide range of cases, is the principle of stare decisis. And perhaps Kiobel was decided and they don't want to challenge Kiobel, particularly in a case where they're defending Sosa as stare decisis against the other justices, some of the conservative justices who want to overrule it. So perhaps they just decided they weren't going to win anyway, stick to stare decisis, let Kiobel stand without being challenged by new evidence plainly showing that it was wrongly decided. A second one is that it's another deal, that what we're seeing is it's conspicuous, although Paul didn't mention, it's conspicuous that the Chief Justice Robertson and Justice Coney Barrett didn't state any opinion. They joined the majority opinion on the extraterritoriality issue, but they didn't say anything about the status of the Sosa case. So there were only 3 justices to effectively overrule Sosa. Barrett and Roberts didn't speak to the issue. And I rather suspect that there was some kind of deal with the 3 liberals that if they let go and accepted Kiobel and didn't make trouble and didn't embarrass the Chief Justice and make him have to go back and say why he's now rejecting this compelling evidence, that it would be that he would not join, the 2 of them would not join the other conservatives and overrule Sosa. So there's a kind of maybe stable, maybe unstable, but I guess seemingly worth it to the liberals to make to stay their hand on this point. Okay. You're muted.
I'm muted now. Thank you very much, David. And however else this case is interpreted, based on your comments, it seems to be a clear defeat for we legal historians. But there may be a counter to that. So let me turn things over to our next speaker. I'm very happy that as moderator, I'm not in the position of having to debate him, which I have been in previous occasions, always with profit, however. So let me turn things over to Mike Ramsey.
Well, thanks very much, Marty, and thanks to the committee and the association for having me all the way out from California, virtually that is. I want to say that I realize that my presence here is principally to offer some sort of defense for the court. That's complicated by the fact that I agree that there should be jurisdiction under the ATS for cases of this type. And I agree with what you've just heard from David Golliff, that there should not be an extraterritorial limit. Nonetheless, I do think that the court was mostly on the right track in the Nestle case, and I want to try to explain that. So I call this talk the ATS on a clean slate, because I want to start off by talking about the ATS and only sort of back into what the Supreme Court has said about it in the various cases that have been mentioned. And also, sort of parenthetically, I want to be clear that it's also a clean slate with respect to my own writing, including some things that I've said in amicus briefs to the Supreme Court, that it supersedes all things that I have previously said about the ATS. But so here's the way I think about it. I start with the point that the ATS is very similar to the federal diversity jurisdiction statute. It's parallel in language in the terms of granting jurisdiction. And both of them were originally part of the 1789 Judiciary Act. Now, no one thinks that the diversity jurisdiction statute has an extraterritorial limit. It is routinely used to adjudicate claims that arise from things that happen overseas. There's no reason to think that the ATS jurisdiction is any different. It's conveyed in the same kind of language. It grants jurisdiction based on the status of the parties, the nature of the claim. Doesn't say anything about the location of the injuries that are being complained of. So just on its face, it doesn't appear like the diversity jurisdiction statute doesn't appear to have any extraterritorial limit. And as David Golub says, there's reason to think that Congress affirmatively wanted the ATS jurisdiction to extend to overseas activities, in particular to give some remedy for misdeeds of American citizens abroad that might lead to diplomatic and perhaps even military complications for the United States. So I am entirely unpersuaded by the extraterritorial limit that's been proffered by the Supreme Court. And in any event, as to Nestle itself, there's obviously diversity jurisdiction here. It's unclear why the court needs to restrict the ATS jurisdiction because given that this is a alien plaintiff against a U.S. defendant, there is diversity jurisdiction, and diversity jurisdiction doesn't have any extraterritorial limit. So that's point number one. But so it's, to that extent, I agree with the panels that you've heard so far. But here's point number two. Jurisdiction is different from a cause of action. No one thinks that diversity jurisdiction gives a federal cause of action. And again, the ATS is parallel. It speaks only to jurisdiction. There's no reason to think that it gives a federal cause of action either. Now, as you've heard, in Sosa, the Supreme Court rejected this idea and embraced the idea of the ATS licensing the creation of federal causes of action by the federal courts. The Supreme Court in Sosa said, without this, the ATS would be meaningless. But that's obviously wrong. No one thinks diversity jurisdiction statute is meaningless because it doesn't create or doesn't license federal courts to create a federal cause of action. As with diversity jurisdiction, where a statute only gives federal jurisdiction, the cause of action comes from another source of law. And here, that most obviously is local law. Maybe Ivory Coast law. Well, it would be Ivory Coast law. And maybe if something illegal happened in the United States, it could be state law. That's how the case would proceed if it had been filed under diversity jurisdiction. And because I see ATS jurisdiction as being substantially parallel to diversity jurisdiction, it seems to me that that's the way this case should proceed as well. Now, parenthetically, you might ask, what's the point of the ATS if it duplicates diversity jurisdiction? But it doesn't exactly duplicate diversity jurisdiction. In particular, the ATS doesn't have an amount in controversy limit. The ATS provides federal jurisdiction where diversity jurisdiction doesn't, particularly because of the amount in controversy. And this is not a trivial point because the original diversity jurisdiction statute in 1789 Judiciary Act had what was for the time a fairly high and an intentionally high amount in controversy requirement. So what the ATS did was it allowed these type suits, international lawsuits, to be brought without the amount of controversy limitation. So if that's the right way to think about it, which is the way I am at least currently thinking about it, what are the implications for the Supreme Court? Well, as you've heard, there appear to be 3 votes, but only 3 votes for something like my view. That is Alito, Gorsuch, and Thomas. Although they seem to have this sort of odd view that if there's no federal cause of action under the ATS, there's no cause of action at all. And that strikes me as completely baffling. But leaving that point aside, I think they are on to this idea that a statute which says it provides jurisdiction and doesn't say anything else provides jurisdiction and nothing else. And I think that position although it got only 3 votes in Nestle, is still very much of a live position, because there are a number of justices who are not committing themselves one way or the other on that. They're simply sticking with the extraterritoriality, using that to deflect case after case that comes to them, Kiobel, Jesner, and now Nestle. And it's not clear what they would do if presented with a case that couldn't be deflected on some other ground. But in any event, for the moment, we don't have anything more on this point about the source of the cause of action. The court's majority, instead, as you heard, strongly reaffirmed its extraterritorial approach, in spite of the best efforts of David Goloff and others. And I think that the jurisprudential significance of Nestle really is that the court means what it says about extraterritoriality, and they're going to read it pretty strictly, so that, for example, not just being a U.S. corporation or just taking generalized corporate decisions in the U.S. Is not enough. Could there be more? Could you get jurisdiction if there was more? Hard to say what the court's going to do about that. It seems to me that a likely future prediction is that they're going to continue to play this cat and mouse of, oh no, that's not good enough for it. No, that's not good enough for it. And that's not good for it. And it will continue. But it's sort of somewhat in defense of the court. The court is really talking about an extraterritorial cause of action, not just jurisdiction. And I do think that well, I don't think there should be any federal cause of action here at all. So I'm actually okay with them deciding that they're going to limit it quite strictly on extraterritoriality, although I would prefer to have it said more cleanly that the statute means what it says and not any more than that. And finally, then, what are the implications for the plaintiffs on this? Well, a question I have, although I have an answer, a speculative answer, is why not just refile this case under diversity jurisdiction, where there's obviously federal jurisdiction, and then a cause of action would come under local law. I don't think the plaintiffs are going to do that, and I think that shows that this case is not really about, and these cases are not really about jurisdiction under the ATS, but rather they're about the desire for a federal cause of action, which the plaintiffs think that, as made up by the federal courts, will be more favorable to them than Ivory Coast law or state law. But that reaffirms for me that the Supreme Court's on the right track. Federal courts don't have any business, in my view, making up federal causes of action, especially for events that occur in foreign countries. If the defendant's actions are illegal under the law of the foreign country, then the plaintiff should have a claim under that law. And they can bring it in federal court under either the ATS or diversity jurisdiction. But if the defendant's actions aren't illegal under foreign law, then U.S. courts should not have any interest in them, unless, of course, U.S. lawmakers provide otherwise. Thanks very much.
Okay, great. Thank you very much, Mike. And now let me turn to someone who I rarely debate on the merits, and that is Beth Stevens. So Beth, take it away.
Okay, thank you, Marty, and thank you to you and Stephen for setting up this committee, which I think is going to be fun and interesting. It's very hard not to take the bait from Mike, but I think I'll leave it to Paul to answer that. Although I will mention that Paul and I have co-authored an article called "Suing for State Law Claims for International Human Rights Abuses." So we have thought a bit about that question. But my more general comments are on both the depressing and then the touch more promising takeaway from this, where we are in the Alien Tort Statute litigation to date. The depressing part is that I'll just say how depressing I find the ATS landscape right now. I don't think it's all over, and I have tremendous faith in Paul's ability to keep it going and keep arguing in the Supreme Court for years to come. But I don't know if he wants to, but the Supreme Court has not just been shutting down the litigation, but doing it in a way that I find very frustrating, which is not taking it on directly, I think. The presumption against extraterritoriality, which they crafted in Kiobel, and that was a case that had the most attenuated ties to the United States, and it could have been dismissed on those grounds. It wasn't just a foreign corporation, foreign plaintiffs, and foreign events. It was a foreign corporation that was being sued in the United States because Royal Dutch Petroleum, the multinational corporation, had a single representative in New York State with an office with a Xerox copying machine. And that was enough for systematic and continuous contacts for general personal jurisdiction under the old rule. By the time the case came up to the Supreme Court, that was no longer the rule for general personal jurisdiction. That case could not be brought in the United States anymore. And as a civil procedure professor, I relished the fact that Royal Dutch Petroleum, with their fancy corporate lawyers, couldn't raise that in the Supreme Court because they had litigated in a parallel case. They hadn't raised it in their first submission to the trial court. They had waived personal jurisdiction. And that, something that I teach to my first year law students. But it was very frustrating because that it could have been dismissed on that ground. Didn't need to make this bad law. So I think that the court was looking for this bad law, and I think it's relevant that it was against a corporation. Kennedy was the fifth vote on the opinion about extraterritoriality. Kennedy had a love affair with corporations, it seems, from his opinion about corporate First Amendment rights and his later opinion in Jesner, both where he waxed eloquent about the important role that corporations play and their voice. And so and the opinion was entirely, the opinions really are geared to corporations. So another part that I find frustrating about this whole line of cases is that they haven't decided since Alvarez a case against an individual defendant. They haven't addressed touch and concern or extraterritoriality in terms of individual plaintiffs, individual defendants. After Kiobel, it seemed to me to be completely open that the case didn't apply to defendants like in the original Flaherty case who were living in the United States at the time they were sued. And for example, and to cases where the abuse took place and then the defendant relocated to the United States. And that could have been considered a sufficient tie. But the lower courts have thrown out almost all of those cases. The Supreme Court has not taken cert to say, oh no, that's not what we meant. And the language in Nestle seems to suggest that fact pattern wouldn't be sufficient because the living in the United States isn't conduct related to the abuse in any way. And I just find frustrating is the word I've been using. I just, drives me nuts that they don't actually address that issue, indicate in any way that that's what they had in mind. But those cases at this point are even less likely to continue because although it's not impossible to have fact pattern where a defendant in the United States is committing abuses in a foreign country, chances are there'd be jurisdiction under US law, you wouldn't need it. Chances are, as opposed to a corporation, but those are presumably gone. But you know, in additional depressing comment about this past 20 years or so of Supreme Court doctrine, and some of it perhaps going back even further, the Supreme Court has been shutting down litigation all over the place, a whole series of decisions, including the general personal jurisdiction over corporations, and we know the standards for pleading and the right to sue and understanding of common law is what some scholars have labeled a profound hostility to litigation as a means to obtain justice. So we're in good company here in our Alien Tort Statute litigation. But on the other hand, there is a different picture, a larger picture, and a both national and international picture, which is, you know, I feel like it's more promising if I kind of squint and turn my head sideways and look in just the right way. I can see something a little bit more optimistic. But that's that the goal of the human rights litigation, of Alien Tort Statute litigation, is to get redress for individual plaintiffs, but it's also to promote human rights accountability and accountability for violations, to create and expand the mechanisms available. So each case represents hundreds and thousands of survivors who couldn't sue can't seek redress in any other way, can't seek redress in the Ivory Coast. And each new mechanism opens a way to another group of survivors who can get some kind of redress. So I wrote about this in 20 years ago in something I called Translating Flaherty, that people looking for ways to promote human rights accountability in different ways in the United States and around the world. At the time, 20 years ago, I kept a running list of all of the cases of international human rights claims in courts around the world. I mean, it seems kind of astonishing now. Of course, we didn't have quite the same internet capability, so who knows how many I missed. But now, that's long gone. There are hundreds of cases that are listed, publicly available, and they're in the countries where the abuses took place. They're in places where the individual defendants have relocated, and they're in places where the corporations are headquartered, which is so key in the Nestle case. There also are different statutes in the United States, which are, I think were triggered in part by the Alien Tort Statute litigation. Clearly the Torture Victim Protection Act, which creates a specific cause of action for torture or extrajudicial execution, which we know was triggered by Alien Tort Statute cases, and which is a viable extraterritorial mechanism for litigation. Additional ones, the Trafficking Victims Protection Reauthorization Act, the TVPRA, which also creates a civil claim for human rights abuse, trafficking, and is being used today to try to hold corporations and other individual defendants accountable. There's also a broader corporate accountability movement, which has led to various actions in the United Nations to a push for a UN treaty on business and human rights. Not alien toward, not direct outgrowths of the corporate defendant cases in the United States, but all part of the same landscape. So early in the Alien Tort Statute litigation, we were able to articulate a very exciting potential about these cases, that oppressors around the world were going to change their behavior out of fear that they might be sued, that corporations would clean up their act because they were worried about these multi-million dollar, hundreds of millions of dollar potential liability. It was an exciting possibility. I don't tend to be an optimistic person in general, and I expected that it would get shut down. I thought it would get shut down when it reached the Supreme Court, and my now deceased colleague, Michael Leitner, and I used to say that our task was to keep it out of the Supreme Court. So the first time it got to the Supreme Court in Paul's competent hands, we won. I was totally astonished. I didn't expect it in general. When we got to the Supreme Court, I didn't expect that we could win, that Paul could win SOSA. But in the longer run, the corporations and the powerful human rights abusers, in my view, have regrouped and found ways to protect themselves, to evade accountability, something which again comes as no surprise. But despite that pessimistic conclusion, I do intend this my second point, my last point, to be somewhat optimistic. And the ATS litigation hasn't triggered a human rights revolution or upended the international power imbalance that protects abusive individuals and corporations, but of course not. But it has contributed to an impressive outpouring of accountability mechanisms and a modicum of accountability in some important cases. And yes, there's still a lot to be done, but that's no small accomplishment, those modest gains.
Okay, thank you very much, Beth. Still doesn't give solace to legal historians, arguably, but we'll take whatever we can get. So we are going to 7:30 New York time. So first, let me ask. If anyone in the audience has any questions for the panelists, put them in the chat function. Meantime, let me invite the panelists to comment on one another's reflections, if anyone wants to. Okay. No. Go ahead, David.
I'll just briefly say in response to Mike, obviously the issues that he's raising can't be addressed usefully in this type of setting. So, but I do want to point out that in Randolph's memo, he makes the following point. I'll give a quote about, he says, in explaining why it was sufficient to enable a non-statutory prosecution of a defendant for an American for a violation of the law of nations. He explains two things. There were two reasons. One is, as he says, the law of nations is attached to the United States from the nature of the subject without an express adoption of it. And then goes on to say, and the Judiciary Act in Section 11 gives the United States cognizance, the federal courts, cognizance of all crimes cognizable under the authority of the United States. And it being the case that the law of nations is attached to the United States without an express adoption of it. And there's a jurisdictional provision which provides the courts with jurisdiction over suits, criminal cases cognizable under the authority of the United States. That is a sufficient basis for a federal prosecution. So, I don't think that Mike's interpretation accurately reflects the way at least Edmund Randolph and Thomas Jefferson understood in 1792 how the Alien Tort Statute would operate, or the status of the law of nations in American law.
Okay. And Mike, any response?
Well, I agree with David that that this could be debated at great length, and we don't have the time or the patience of the audience to go into the details. But I mean, just a couple quick things. I don't think that the criminal necessarily translates to the civil. I think things were done differently under civil law then. Of course, it's complicated by the idea of general common law, which was prevalent then and is no longer post Erie. But also, there were differences of opinion about federal common law. I'm sorry, excuse me, federal criminal common law, including differences of opinion within Jefferson's own mind, and the idea of federal criminal common law was rejected shortly thereafter. So I don't know, for both reasons, I don't know that I would put that much weight on that. My impression is that in general terms, when a suit of that, a civil suit of the nature of in the nature of tort was brought, that it would be decided under the applicable law of tort, whatever that applicable law was, and which might be general common law. But to the extent that there was a specific law of the local jurisdiction, where the injury occurred, wherever that was, then that law would be applied rather than general common law. So I think it actually, I mean, translating across Erie is a challenge, but I think actually it translates reasonably well. And moreover, I don't think there's in the modern situation, there's any real reason not to translate it as I have suggested. I just wanted to say one quick thing in response to what Beth Stevens said, almost all of which I agree with, but the implications perhaps we don't agree on, which is that if Congress wants to create a federal cause of action here, they can easily do it. They have the power on Article 1, Section 8 to define and punish crimes against the law of nations. And that's what they would be doing here. And there's absolutely no doubt that they could create a cause of action, including an extraterritorial cause of action. And I think there's good arguments that that's exactly what they should do.
Well, great. And as to the historical debate, I would just tell everyone to stay tuned to your favorite law reviews, because I'm sure we'll be hearing more about this in detail.
Marty, can I say something in response?
Yeah,
to
one thing, Paul, and then I want to go to Stephen. Go ahead.
Well, this is the litigator perspective. I mean, it's an interesting debate, but it seems to me that one of the things that this means is that SOSA's resolution of this debate is unlikely to be changed anytime soon. I don't think we're going to get to Michael's position. And even Gorsuch doesn't seem to be all that interested in the Bellier and Clark thesis in what he wrote here. So, he went into all that history, and Jessner, he's sort of abandoned that. Not abandoned it, but he's certainly not pushing it very hard. So, I think that, in terms of the practical litigation consequences of this, is that we're still operating within the SOSA framework. And I think what we're going to do is fight out some of these issues, including the historical issues, in the context of focus. What does focus mean? They've left that open. So focus is the new touch and concern in the context of presumption against extraterritoriality. And I'm not entirely convinced that US citizenship is now irrelevant. I mean, I think it remains to be seen. I think that their adoption of the RJR Nabisco framework and the way they did is certainly not the position we advanced in our briefing, so that's a negative. But they also left open a lot of these debates, and I think they left it open to what's going to happen in the lower courts. And they probably won't take another one of these cases for 2 or 3 or 4 or 5 years, and then they'll decide based on what happens in the lower courts, probably. And we may be arguing the same things again, maybe on the 25th anniversary of SOSA, if I'm still walking.
Well, we certainly hope you are, Paul. So before I go to the audience, I think I should go to the co-chair of this committee, who himself has a track record in this type of litigation. So, Stephen.
Well, thank you, Marty. Yeah, track record is right. I was in the courtroom when Flaherty was argued in 1979 or 80. Seems like only yesterday. But I have actually 2 questions, but let me put the first one, and maybe we won't have time to get to the second. I don't understand. I simply don't understand why we are talking about extraterritoriality here at all. I don't get it. I'm sorry. I think that the Chief Justice got it just entirely wrong, as in ungrammatical in the decision in Kilble. And here's why I say that. I mean, he's relying on cases like Morrison and Aramco. Those were cases in which the question before the court was whether a normative statute, a thou shalt or thou shalt not type statute, was enacted by Congress. And the question is, does it reach overseas conduct? That's not what the ATS does. The ATS, as Justice Souter told us in Sosa, means what it says and says what it means. It's a jurisdictional statute. That's all it is. It doesn't regulate conduct. So I don't understand what it means for it to apply or not to apply extraterritorially. I get the idea that the conduct in question may be caught. That is, the conduct in question may give rise to a case in which the federal court has jurisdiction under the ATS, whether the act arose overseas or in the US or somewhere else. That makes sense to me, but the word extraterritoriality just seems to me to be misplaced and misleading and taking us all in a direction that doesn't need to be explored. So any reaction to that would be good, but here's the very simple question. In Nestle, the court gave us very, very little more than it gave us in Gessner. In Gessner and Kilble, we heard that you need to have more than corporate presence. Now you need to have more than general corporate activity. I'm not sure what the difference is. So that raises the question in my mind, and I'd love to hear especially Paul's view on this. Why did the court grant cert in this case?
Paul.
I think that might be above my pay grade. I think that first of all, they asked the Solicitor General for its views, right, in connection with the cert petition. Solicitor General came in and said, you ought to take this case for a whole variety of reasons, including doing away with aiding and abetting liability, and we don't agree with our prior position on corporate liability because of your decision in Gessner. So you had the administration coming in and saying, take this case. You had the corporations basically saying, wipe out the ATS in a variety of ways where they said it. Why 4 of them or more wanted to have that discussion, I don't know. And I think that when they actually heard the arguments, and when you're talking about a case involving child slavery with the kind of facts that exist on the ground in the Ivory Coast, I don't know, maybe they had a different idea. And, on your presumption, one of the things that we briefed, and David obviously was part of this in terms of amicus participation, in a lot of ways, our briefing was a gentle statement to Roberts, you really got Kiobel wrong for all the reasons you said. And that's where the significance of Jefferson and Randolph came in, it seemed to me. And that's why I pressed them in the argument. It's like, well, okay, there's new evidence now. You didn't think the evidence of the Bradford opinion from 1795 was anything more than ambiguous. Piracy was a special case. That's how he wrote it in Kiobel. After you look at these memoranda, you can't look at it that way anymore. And so from our standpoint, we were pushing for Roberts to take a new view of this on this issue, right? And to find that it was different when it was a US citizen rather than a foreign cube case. They obviously didn't do that. and you could speculate, I don't know, I mean, maybe Roberts, it seems to me obvious from the 8 justice opinion and the fact that it took them, 6.5 months to decide this case in a tiny little opinion, that there was a lot of horse trading going on here. I mean, this was clearly a brokered opinion, right, I think. And I think it was a brokered opinion where they couldn't decide, they couldn't decide which way to go in this context. And so they punted. That's how I read it. They punted on the underlying issue and left it for another day about how to resolve all these questions about what kind of conduct and what aiding and abetting means and all that stuff. They basically said, well, and from our standpoint, if we were going to lose, this was the best possible way to lose. right? In fact, it's actually better than what we thought the best possible way to lose was, because we got corporate liability. And so, you know, I'd much prefer to win, generally speaking. But if I'm going to lose, this was okay. You know, leaves us open to fight another day.
I might say a word about Stephen's first question. Again, subject to all the reservations that I said about extraterritoriality in my opening comments, but I think you have to think of the ATS as the Supreme Court's thinking of the ATS as doing two things: one, giving federal jurisdiction, and two, authorizing the federal courts to create federal causes of action. If you don't think it does those two things, then you're with me and you think it does only the first one. And if that's right, then clearly there shouldn't be any extraterritoriality, but it might be. But that's not the way the court thinks about it. The court thinks about it as that this is a statute that says, Section 1, there shall be federal jurisdiction. Section 2, there shall be a federal cause of action. Or the courts are authorized to create a federal cause of action. So then the question is, what is the scope of the federal cause of action? And that's what the extraterritoriality applies to. And then the court says, we're not going to create an extraterritorial cause of action unless we have real clear guidance from Congress that that's what we should be doing. And we don't see that here. Now, I agree that number one, that's sort of an awkward way of looking at the whole thing. And number two, the court didn't do a real good job of explaining that that's what it meant. But I think that has to be the way to understand it, because it can't be the case that jurisdictional statutes, as to the scope of jurisdiction, are subject to an extraterritorial limit, because diversity jurisdiction statute is not subject to that, and nobody doubts it. So it has to be understood as a limit on the court-created cause of action. And then it's sort of awkward to say Congress didn't give an indication, because Congress didn't give an indication that there should be a court cause of action in the first place. But once you get past that, then you get into the sort of alternate universe that the court's in here, where the Congress authorized the cause of action. And then the question is, what's the territorial scope of the cause of action? So that's the way I would think about what's going on with the application of with Morrison and such like.
So I just want to, I agree with I think the main point in response to your question, Stephen, that Mike just offered. I just again want to emphasize, though, that once the court has made the leap, for Mike anyway, from the jurisdictional statute to an implicit authorization to create federal common law, once that is accepted, if you're trying to in any way stay true to the intentions of the Congress that passed the Alien Tort Statute within that framework, then it would make no sense to restrict the scope of that federal cause of action territorially, given what we know about the history at this point. It's very overdetermined. Clearly, no one really doubts that a core purpose, this may not be the exclusive purpose, but everyone agrees a core purpose was to open the federal courts to suits by aliens who had been injured by American citizens in tort actions, so as to avoid the United States being implicated in the misconduct of their citizens. And everyone also can see, who looks at the history, I think, at all seriously, that it didn't matter whether or not the misconduct or tortious misconduct of the American citizen occurred in South Carolina or in East Florida. They didn't, that wasn't relevant to the problem that was being addressed by the Alien Tort Statute, which was as core, making sure the United States could disavow, separate itself from the torts committed by American citizens in violation of the rights of other countries. So, leaving aside, a debate about whether we should think of the cause of action as federally created through a common law process, and whether or not there was a understanding of, let's just say, federal common law at the time the Alien Tort Statute was passed in 1789, whether the disavowal of the federal common law, Mike said it happened shortly after this period, but in fact, it continues until 1812 in a very famous case, the Hudson and Goodwin case. It's incredibly contested. It goes to the deepest political conflicts between the emerging Republican Party and the Federalist Party and so on. This is a major feature of the 1790s and the 1800s, essentially about this. Federal common law is very pervasive in this early period, and including obviously the Judiciary Act, the time of the Judiciary Act, which was 1789. But I do think that Mike is right, that when charity requires us to say that the court, when it's speaking of extraterritoriality here, isn't speaking of jurisdiction. They're speaking of the substantive scope of liability under the cause of action.
So we only have a few minutes left, and I should take one question we have from the audience, which I think may get to the translation past Erie point that Mike mentioned. So it is from Joseph Della Penna, who asks, a good deal of customary international law survives the demise of general federal common law in 1938 under Erie. Why isn't that sufficient for a cause of action? Or I guess I should say, why isn't the survival of per Jessup of the federal courts being able to fashion something like federal common law, depending on how you read Sabatino, post-Erie, suffice as a basis to create an extraterritorial cause of action for a violation of customary international law?
I mean, that was part of the reasoning in Souter's opinion in Sosa.
Right.
I
Right.
mean, that he basically said that the original Congress would have thought that the courts had the ability to enforce the law of nations through federal common law, and that they didn't require a cause of action, and that translating that to the present, the fact that Erie ended general common law did not end their ability to recognize causes of claims based on the law of nations. And I think that's, the answer is that Sosa did recognize that and did reject arguments that Erie ended it. And I think, I think it's still very significant that the court has not overturned Sosa, notwithstanding the fact that it's been asked to do that directly and indirectly, ever since it came out.
So any final thoughts from anyone?
Well, I might say a word on that, since I think the audience question, since I think it was sort of directed at me.
Yeah.
So I think that as far as I'm aware, that federal causes of action based on customary international law did not persist after Erie outside of maritime law, which is very much its own thing, both internationally and in the constitutional system. That's why Sabatino assumed such significance in these debates, because Sabatino appeared to be an example of federal common law that implicated international relations. But two things about Sabatino. Number one, it was not based on international law. It was based on domestic separation of powers. And number two, it did not recognize a federal common law cause of action. Quite the contrary, it defeated a plaintiff's claim. And so I don't think that there is, in fact, precedence for federal common law causes of action under international law post-Erie. And just one quick last point is, if there were, we would not need the Alien Tort Statute because they would persist under the diversity statute as well.
Okay. Which is in part why I said it depends on how you read Erie. So any final words? We're just about up against time. David, did you want to say?
No, no, it's all right.
Yeah. So any final words from anyone? Perhaps Paul, since you argued the case, I'll give you the last word.
I think I've probably said enough words already. From my standpoint, I think, the bottom line of this is you're going to see a lot more litigation about corporate accountability cases under the Alien Tort Statute. And I think trying to predict how the lower courts or the Supreme Court will go on this is, I can't. I'm just going to litigate them. Others will decide.
Well, it looks like this issue, among others, will keep this new committee of Avila in business. So with that, on behalf of Stephen and myself, let me thank the panelists for just a phenomenal discussion. It was wide-ranging, deep, and I thought I was on top of this stuff, but I learned a lot. And so thank you all for taking time out. And for everyone in the audience, stay tuned for other events that this committee will put on, and also stay tuned for this fall's International Law Weekend in October, which will probably be still virtual, but hopefully we may have a physical venue back at Fordham Law School in New York as well. So thank you all and have a great evening. Take care.